Was the I-130 denied for not enough evidence or for fraud? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, San Diego, and Washington, D.C. I can honestly not believe how many cases we're seeing these days where someone comes to us with a denial of a current immigration application because of a prior immigrant visa or immigration application. What do I mean by that? Well, we're seeing situations where people have applied for a green card in the past, usually based on marriage, and that marriage was deemed to be insufficient. And they will send us a copy of their denial. Now, the one point that I want to make in this video more than any other is that not all denials are created equally. Some denials are much more serious than other denials. And in the whole pantheon of denials, the most important one and the most deadly one and the most fatal one are denials based on a finding of fraud. Now, USCIS throws around fraud pretty freely, but they have gotten better at nailing down situations that they think are fraud. In other words, they've gotten better at going out and getting the evidence to develop that a application was fraudulently applied for and that the application was denied because USCIS found fraud. So they're very easy to throw around that term, and fraud is actually a hard thing to prove, and of course it's not necessarily their burden to prove it, but if they're going to make allegations, they have to be able to back them up. And so we see a lot of these denials, and when the denial comes in, the question that I and the other immigration lawyers in the office are asking ourselves is, well, was this just an outright denial because you didn't submit enough evidence, or was this a denial because you didn't have a true marriage, that it was a fake marriage, and that they believe that you committed immigration fraud? Because the reason this is so important is that if it was just a finding that the marriage case was not strong enough, that you didn't submit enough evidence, that's one thing. That's something that you can overcome either through marriage to that person and just filing a stronger case, or if you ended up getting divorced, filing a new strong case with your new spouse. What you don't want to have is the other option, which is where USCIS says that you committed fraud. And fraud has very serious consequences. In fact, I recently signed up a case, and I didn't realize the degree to which USCIS had found the fraud. And one of our great paralegals named Florencia talked to me, and she went ahead and said, Jim, you can't proceed with this case. This case has serious problems, and you need to make sure that you don't proceed with this case because the client had a fraud finding, and we ended up giving those people their money back and turning down that case. So a fraud finding has very serious consequences for the future. Let's say that you had a U.S. citizen child and that child turns 21 and you want to apply for that child, or you want that child to apply for you. If you have a finding of fraud from a prior marriage case, that too can keep you. So it's very important to figure out what the deal is with the denials and what the actual findings of. So we actually spend a lot of time going over the denial, figuring out why was it denied, and then dealing with that as we decide whether or not to proceed with the new case. So not all denials are created equally. If you have questions about this, give us a call, 314-961-8200. Email us, info@hackinglawpractice.com. Be sure to join us in our Facebook group, which is called Immigrant Home. If you like this video, we ask that you please share it out on social, that you subscribe to our YouTube channel, and that you join us on Tuesdays and Thursdays, usually at noon Central, in our Immigration Answer Show, where I'll try to answer as many of your immigration law-related questions as possible. Thanks a lot, and have a great day.